Oh, my chair's gone.
They took my chair. Did you see that, guys?
All right, so I'm Jackson Blodgett, and then we have Allison Axelrod, Tyler Brothman, Andrea Rodriguez, and Lindsay Sekula, and we're going to be going over human resource law. So I'll be doing the Age Discrimination and Employment Act as well as the Fair Labor and Standard Act, and they'll be going over a series of other laws. So the Age Discrimination and Employment Act, it says you can't discriminate in any way against a person in the or against an employee or against an applicant based on their age. So this prohibits discrimination in hiring, firing, job assignments, promotions, and any other aspect. Age harassment is unlawful as well, and this is, like an example of this is a derogatory or offensive remark about someone's age, and the harasser could be anyone. It could be your supervisor, another supervisor, a coworker, or even a client. So after the Equal Employment Opportunity Act of 1964 was passed, it opened up the floodgates for awareness of other unequal employment situations. So there were widely spread stereotypes about elderly people, which affected their getting jobs. So the Secretary of Labor was asked to do a study. So people over 45 were barred from a quarter of the jobs that they applied for just because of their age. Over 55, they're barred from half those jobs. And over 65, there's almost no statistical chance of getting a job at all. So this is regulated by the Equal Employment Opportunity Commission. And there is one exception to this law. If you may not hire someone solely based on their age, if that person is going to be a danger to themselves or other people, such as an elderly man driving a crane. You don't want them to fall asleep or anything. So originally, this only applied to people 40 to 70 applying for private sector. And then in 1974, it was changed to also allow state and federal jobs. And then in 1986, the upper age limit was removed. Then in 1990, a loophole was corrected. So in 2009, there was a case that Gross versus FPL Financial Services, and it ruled that it's now up to the employee to prove that they were discriminated against. Before this, it was up to the company to prove that they would have made the same decision regardless of the employee's age. So summary, ageism is like sexism or racism, and it has no place in the workforce, and because of this act, now it is illegal, and you can be prosecuted because of it. So as we move into the Fair Labor and Standards Act, I'm going to tell you a little story. So when I was younger, that's me working in a pizza shop, and my employer only hired people like me who are young and dumb and don't know any better. And he's working us
Young, dumb, and broke.
yeah, working us 80 hours a week, like below minimum wage, and not paying us for overtime and stuff. And I was very overworked, and so were my coworkers. So this was a problem back in the 1930s and before that. People were overworked and employers were taking advantage of their employees, and there were no repercussions because of it. So there's a story about how this came into place. So when Franklin Roosevelt was campaigning to be president in 1936, he was on his campaign trail and a woman approached him and handed him a letter that said her and 200 other employees, women employees, were working at a factory and they're getting paid $11 an hour. And all of a sudden the employer said, now you're making $4 an hour. And they can't live off that, and no one can. So he did something, and 2 years later, he passed the Fair Labor Standards Act of 1938. So it was created, like I said, 2 years after he came into office, and it was created so that their employers couldn't take advantage of employees anymore. And it goes over a couple things. First is minimum wage. So now for the first time, there is a federal minimum wage that all companies, public or private or state, have to follow. And states can actually opt to have a higher minimum wage, but it has to be higher than that federal level. So the next thing it goes over is break time for nursing mothers. This is Dora and Mrs. Explora. So before this, Mrs. Explora, she wanted to nurse her child in an hourly job or feed her child. Her employer could say, if you get up, you're fired, and you have to feed your kids. So that's not right. That was fixed. The next is overtime compensation. So now, as you guys know, any hours over 40 hours during the work week, you have to be paid time and a half for. So this stops employers from saying, all right, well, I have to pay you this new minimum wage, and you're going to work 90 hours to make up for that. Final thing it goes over is child labor. Most jobs you have to be 16 to work at, and they also cannot work in hazardous or dangerous conditions, because as you can see from this picture before that, you had kids working in factories and get themselves hurt. The last thing is their work can't interfere with school, so as long as they can't work at certain hours. There are some exceptions. The tipping wage, I believe, is $2.13. It was created because your tips plus that wage is supposed to equal minimum wage, and people with disabilities could actually be paid less because you're giving them an opportunity that they wouldn't have otherwise. And that goes the same for youth opportunity wage. So this is regulated by a specific unit of the Department of Labor called the Wage and Hour Division. And the FLSA is updated constantly to keep up with modern times. For instance, the federal minimum wage is now $7.25. So to summarize, HR laws prevent injustice and unfair treatment in the workplace, and the ones that they will be going over are very important as well.
All right, hi everyone. So I'm going to be presenting and focusing on the Occupational Safety and Health Administration, as well as the Mine Safety and Health Administration. So if you're a management major or you've taken writing as managers, you should know a little bit about OSHA because there were a few situational case studies that we focused on in that class. So Congress created OSHA with the Occupational Safety and Health Act of 1970 in order to assure a safe and healthful working condition for all working men and women. This goal is achieved by setting and enforcing standards and by providing training, outreach, education, and assistance. So there are OSHA training institutes, education centers that are nonprofit organizations approved by OSHA in order to help OSHA achieve their goal. So employers have a whole list of things that they have to do, but the main thing that they have to do is display the job safety and health, it's the law poster, which explains all the rules and regulations and anything that employers need to know about OSHA, as well as just doing safe tests and providing their employees with personal protective equipment. So on their website, there's an organizational chart, which is right here on the PowerPoint, and it's important to note that OSHA covers all 50 states, Washington, D.C., and all other jurisdictions. So they make sure to update the slide so that people have a point of contact when they do need it. In this map, the lighter shade shows the OSHA approved state plans for both private and public. The darker shade are the federal OSHA for both private and public, and the stripe is where New Jersey falls under, which is for public employees only, the state approved plans, and the federal OSHA for all private sector employees. So the hazard prevention and control has 6 action items. The first being identifying control options, the second being selecting, then developing and updating, then selecting control options when there are non-routine ops, implementing and following up. Focusing on the second action item, there is the hierarchy of control. So this ranges from least effective to most effective. Least effective being the personal protective equipment that you must wear, and the most effective being elimination, so just eliminating any hazard that's in the way or that's anything that could be chemical or anything that could hurt anyone. So that's me. The past 2 summers I've had internships at L'Oreal. My first year was research and innovation for skincare, and my second was corporate supply chain management, and human resources training and development. So I got to train all of the managers and supervisors in the distribution centers in North America. And in R&I, the first thing I learned was if I were to step into the lab, I had to make sure I was wearing all three of those things. So I had steel-toed shoes that obviously L'Oreal provided, the protective glasses, and the lab coat. In regards to the distribution centers, I didn't work directly in them, but I still had to learn what you had to wear. So if you were working any heavy machinery, you needed the hard hat. But if you were just pallet picking any individual products that were going to be shipped, you needed the vest and the glasses, just so that people knew you were there, and in case anything happened, your eyes were protected. So how many people have seen these hazard signs? I'm sure most of you have. So the colors obviously depict a different type of hazard: health, fire, specific, or the reactivity. And the numbers depict the type or the severity of the hazard, ranging from 0 to 4, 0 being minimal and 4 being a severe hazard. So when it comes to working in labs, for example, you have to make sure that when you're dumping any of the waste, that you dump it in the proper container that has the proper label to prevent anything serious or hazardous from occurring. So similar to OSHA is the Mine Safety and Health Administration. So they work to prevent death and illness and injury from mining and to promote a safe and healthy working environment. The difference here is that they follow the Federal Mine Safety and Health Act of 1977, whereas OSHA is the OSHA Act of 1970. So there are a few key components, and the first would be there are 4 annual inspections for all of the underground mines and 2 annual inspections for any surface mines. The overall act expands rights, enhances protection. There are mandatory training and mandatory rescue teams for all underground mines. Something I wanted to point out was that in 1981, the first statute was passed. And 50 years later, there was finally federal inspectors allowed to go into the mines. And in 1961, studies were finally authorized to see how dangerous working in mines are. In 1973, MESA was then created, and almost 100 years after the first statute was passed, MSHA, the administration that we now follow, was created. And in 2016, the Mine Improvement and New Emergency Response Act was just passed. So that was just only 12 years ago, so fairly recent. In regards to mining fatalities, in 1978, so the year after the act was passed, there were 242 fatalities, and in 2015, that number decreased to 28. So clearly, the rules and regulations were set for a reason, and although obviously the number isn't 0, it still proves that it makes a difference. For MSHA, the only difference for inspections would be number 5, programmed inspections, because it depends on the type of mine. So obviously, underground would be 4, surface would be 2. But in regards to the overall inspections for both OSHA and MSHA, they're fairly similar. And just overall, clearly OSHA and MSHA are vital to the workplace's safety, and the number of fatalities decreasing and injuries decreasing proves that. So I'm going to pass it on to Allison.
I'm going to be going over the Family Medical Leave Act, which is also known as FMLA. And this is the United States federal law requiring employers to provide employees with protected job leave and unpaid leave for qualified family and medical reasons. And some reasons could include family illness, personal illness, or family military leave. And some history about this law was that it was passed in January of 1993, and it was actually passed by President Bill Clinton, and was known as his first accomplishment of his new administration. And it was actually introduced to Congress every year from 1984 to 1993. So it was actually introduced for 9 years until President Bill Clinton passed this law. And it was originally known as a National Partnership for Women. In 1984, it was known as the Women's Legal Defense Team. And this was the first national law that was designed to help Americans meet the needs of family and a workplace. So it allowed them to not have to choose family or work. It allowed them to do both at one time. And eligibility for this, many people actually can't afford to take the Family Medical Leave Act. but 40% of the workplace is actually not eligible for this, so only leaving 60% of the workplace even being able to be qualified for this. But an employee must work with the company for at least a year and have worked a total of 1,250 hours to qualify for this. But an employer is actually allowed to ask you to leave the company in your absence, but they're only allowed to pose the questions to the employee, not the employer. But you may be required to obtain additional medical certifications at the company's expense if somebody asks you why you're still out on Family Medical Leave Act, since you're only allowed to take 12 weeks with this. And actually only 11 states qualify for the Family Medical Leave Act, and that includes California, Connecticut, Hawaii, Maine, Minnesota, New Jersey,
That's an open
Oregon.
carry state. Or you can carry guns, whichever one you want.
Yeah. Oregon, Rhode Island, Vermont, Washington, and Wisconsin are the only states that allow you to qualify for Family Medical Leave Act. And I actually worked at the protocol group over the summer and into this fall, and someone had to take the Family Medical Leave Act after being rushed into the hospital and had surgery, was in there for over 3 weeks. And her husband was actually able to come into the Human Resources office to fill out FMLA paperwork, so his wife could still have the job when she came back from being sick. And the extended time off, so like I said earlier, Family Medical Leave Act is required to give you 12 weeks off, but this can also be paired with the Americans Disability Act to give you extended time off if you're needed to. And an employer is supposed to make accommodations for the employee, but if it is qualified as an undue hardship on the employer, they don't have to. And just some updates about this is that in 2019, rules to this were updated and implemented a new Military Family Leave Act, and they actually said that pregnancy complications counted against the 12 weeks of the Family Medical Leave Act. And in conclusion, FMLA was designed to help employees balance their work life and family responsibilities. And the unpaid leave is to protect employees' jobs after the employee has been with the company for a certain amount of time. So if you're loyal to your employer for being there for more than the extended year, then the employer basically returns that favor and gives you the benefits if something were to occur and you were to get sick. And the next law I'm going to be talking about is the Pregnancy Discrimination Act. And this was passed in 1978 as a United States federal statute, and it covers only employers with 15 or more employees, including state and local governments. And some history about this is this act amended the Title VII Rights Act of 1964 to prohibit sex discrimination on the basis of pregnancy. Because before this, women were not getting hired for jobs if they were pregnant, because they would be leaving the company after they had their child if they needed to. So that's why they enacted this law, and it overturns the civil rights. And this was passed in 1978 that you cannot discriminate against pregnant women in the workplace. So they will receive all the same benefits as any other employee, so that they're getting the same rights when they have their child. And some work situations, like I said, this forbids discrimination in the workplace. So like I said earlier, hiring, firing, job assignments, promotions, layoffs, training, and benefits. If you're pregnant, you would receive all the same benefits. It's not fair to fire somebody because they were gonna have a kid and take a couple weeks off when their child was born, or to not give them a promotion. If you're both qualified for the position, just because you're pregnant doesn't mean that you wouldn't get the job anymore. And this is paired with temporary disability also. If a temporary disabled person, they would receive the same exact treatment as a pregnant person. If you're pregnant, you wouldn't receive less of a compensation or pay. It would be the same as a temporary disabled employee. So you'd receive the same amount of leave, vacation time, time off, and pay if it was the same qualification for jobs. And obviously it's wrong to harass somebody, but it's actually illegal when it's frequent and it creates a hostile work environment for them. So if it's considered harassment if a pregnant woman got fired for not doing anything wrong besides being pregnant. And it's just unlawful to harass women because of pregnancy, childbirth, or a medical condition relating to that. And the Parental Leave Act, that an employer allows temporary disabled employees to take disability, must allow a pregnant woman to do the same thing. So I touched on this earlier, but if a company didn't allow a temporary disabled person to take unpaid leave, they don't require them to do the same for a pregnant woman. They basically go hand in hand. And some workplace laws. Pregnant employees have additional rights under Family Leave Act, which is the first law that I talked about today. And it was talked about earlier that an employer must provide them a private room to be able to pump for their child and break time, but that's only for hourly employees, not for everyone. Pregnancy discrimination is just treating women unfairly because of pregnancy and childbirth. And in some workplaces, women have still been discriminated for being pregnant, like not given the job, being fired because they were on sick leave off from work. So they are given the time off still with this act. And in conclusion, the pregnancy must be deemed as a normal, objectifiable condition under pregnancy discrimination. And in July of 2014, a government agency actually issued like a reminder that this act was still in place because it was coming up that a lot of women were getting jobs due to being pregnant. And now Lindsay will take over with her.
Alright, hi guys, I'm going to be presenting two employment laws, the Uniform Services Employment and Reemployment Act and the Immigration Reform and Control Act of 1986. Continuing on to the human resources field, both of these laws are what you're going to want to fully understand. First up is the Uniform Services and Reemployment Act of 1994. This act makes it illegal to discriminate against employees who volunteer or are called into active military duty, and provides framework to protect their civilian employment rights when returning home from active duty. The history of the Uniform Service Employment and Reemployment Act stems back to times where there was increased influxes of service members returning home into the civilian workforce. Examples are after World War II, the Vietnam War, and the Gulf War. This act is a revision to previous veterans employment laws and the Veterans Reemployment Rights laws, which were enacted in 1940. Who does this protect? This law protects service members from any of the uniformed services, such as the Army, Navy, Marine Corps, Air Force, Coast Guard, and National Guard. I'm sure everyone in this room knows someone who is or has served in our military forces. This law protects their rights when they return home. Requirements. In order to qualify for protection under this act, employees must meet the following criteria. They must have left the civilian job, and they must have given prior notice to employer before leaving for their military service. Their active leave must not extend past 5 years, and the separation from the service must not be dishonorable. The escalator principle is another main focus of this act. This states that returning service members must be reemployed to a position that they would have reasonably occurred if they hadn't left for military duty. This position could potentially be higher or at a lower level, hence the escalator, it could go up or down. Reemployment. When returning service member is to be reemployed, employers must make reasonable efforts to qualify a returning service member for their position. This may include refresher training or training necessary to update for the returning position, or accommodating for possible disabilities incurred during their leave. 3 steps exist for employers to accommodate returning employees that become disabled. Employers must make reasonable efforts to accommodate returning individuals with incurred or aggravated disabilities while on duty. If despite reasonable efforts, a person is not qualified for a position, they must be reassigned to equivalent seniority, status, and pay. Circumstances which could lead to a service member's rights being disqualified include being dishonorably discharged from the service, being other than honorably discharged, which is specified separately through each branch, or dropping individuals from roles when absent without authority for more than 3 months. Violations of this act involving federal government employers is investigated by the Office of Special Counsel and the Department of Labor. Violations in the private sector are handled by the Department of Labor and the Department of Justice. In my personal experience, I've seen this law enact at my own job. I'm a server at Gonzal. One of our employees is away on active duty at least like 1 weekend a month, and through this act, their job is secure. So when they come back, we can't take away their job for not being able to work certain weekends of the month. In conclusion, this law is a necessity to protect those who serve in any of our country's uniformed services. Protecting service members' employment rights and reassuring their reemployment is important in taking care of our veterans in the workforce and not to discourage workers from entering the military. The next act I researched is the Immigration Reform and Control Act of 1986. This law was passed in order to control and deter illegal immigration into the United States and make it illegal for employers to knowingly hire unauthorized aliens, as well as allowing some unauthorized immigrants to apply for their legal status. The IRCA was signed into effect in 1986 by President Reagan, also referred to as the Amnesty Bill because he granted amnesty to about 3.2 million immigrants. This was the first revision of American immigration laws in decades, stemming from the Immigration and Nationality Act. There were two main goals of the Immigration Reform and Control Act to allow illegal immigrants who entered the U.S. prior to 1982 to apply for citizenship and to criminalize employing illegal aliens. This is in hopes a way to decrease the amount of illegal aliens entering the country by decreasing the opportunity for employment. The legalization program. Along with restricting work opportunity for illegal aliens, this act was also the first massive effort by the federal government to convert a portion of illegal immigrants' population to a legal status. There were two main groups of immigrants that were granted amnesty, the first being immigrants who resided in the U.S. prior to January 1st of 1982. The second group was the special agricultural workers, who must demonstrate that they have 60 days of seasonal agricultural work experience in qualifying crops, and then they can apply for residency without meeting civics and language requirements otherwise stated. The second major goal of the act was to criminalize employing illegal aliens and sanction three types of activities by employers: knowingly hiring persons unauthorized to work in the U.S., continued employment of persons not authorized to work, and hiring any individual without verifying or correctly documenting identity and eligibility to work. The way that this was verified, employers were responsible for hiring. The way this held employers responsible for hiring illegal aliens was to require them to verify identity and authorization to work through the I-9 form, which is the employment eligibility verification. In conclusion, the IRCA was an important milestone in U.S. law, providing the first major revision of American immigration laws in decades, allowing millions of immigrants to gain legal status and to hold employers responsible for giving employment to those who were legally authorized to work. I'm gonna hand it off to Tyler.
The first law I'm going to go over is Title VII of the Civil Rights Act of 1964. It's basically just all about job discrimination. And what it did is it created protected classes. And I'm going to explain what like protected classes are and like how you fall under them in the next slide. Protected classes, you're not allowed to take injurious actions against someone just because they're in a protected class. And the protected classes is like anything describing your race, your color, your national origin, your gender, religion, and if you're pregnant or not. Title VII protects protected classes in any job-related transaction. What I mean by that is like if you're hiring, firing, promotions and demotions, if you're disciplined, like how they discipline you, like what type of schedule you have, the pay you receive for the job, and also like the job assignments that you receive in your job. Not every company falls under statutory Title VII. You need in a private sector employee needs 15 or more full-time employees. You need to be a labor union, employment agencies, state and local governments, and then most federal government employees. The theories of discrimination are just like the types of discriminations. There's three main ones: disparate treatment, which is overt and like intentional discrimination; mixed motive, which you have legitimate reasons and also discriminatory reasons; and then disparate impact, which is occurs when like if you have a test and it like impacts a certain group, not on purpose, but it still does. The first is disparate treatment. To make a claim, you need to be a plaintiff in a protected class, so anybody who's qualified, like if you're qualified for the position, but you still don't receive it, then and like if you met expectations and the employer still tries to search outside that protected class. And then because it's hard to prove like direct discrimination, once you make a claim, the burden shifts to the employer to provide evidence of a non-discriminatory reason. And then after that, it goes back to the plaintiff, and they have to prove that that evidence was pretense. The next one is mixed motives. Like I said before, mixed motives is both legitimate and it's also discriminatory. The employer has to prove like documents that that, sorry, I forgot the word, that is, doesn't affect the standard issues that impacts. So like I said before, like a height, a weight requirement, a educational requirement, it's all like if a group, sorry, I lost my spot. Sorry. Because gender is also a protected class, sexual harassment extends to employees who are sexually harassed. Sexual harassment like consists of sexual favors or anything of like a sexual conduct. There are 4 types of sexual conduct. There's quid pro quo harassment, which is like you ask for a favor, like sexual favor in return for a promotion, a benefit, a pay increase, anything like that. Second one is a hostile work environment, which is where you allow like the sexual environment to take place and make kind of like the conditions unacceptable. The next is constructive discharge, which is working conditions are so intolerable that a reasonable person in an employee's position would feel compelled to quit. And last is same-sex sexual harassment, which you have to prove that it's based off your gender, not sexual orientation, because sexual orientation isn't covered by Title VII. And employment takes it very serious. I worked at ShopRite, my first and only job I had for 6 years, and it's a union job. I can only remember one person really ever being fired once they got into the union, and it's because of sexual harassment. So it's not a joke. They take it very seriously. The next law I'm going to go over is the ADA, the American Disability Act. It became a law in 1990. It's a civil law, it's a federal law. It's broken down into 5 titles, which I'm going to explain in the next few slides, each title. ADA prohibits discrimination against individuals with disabilities in all areas of public life. That's your job, your school. My high school had a floor just for freshmen, but they still had to put an elevator for them. Like transportation, all private and public sectors. So if you have a business, you need to make accommodations. The first title is Title I, it's employment. It's the same thing with the 15 employees you need for it to actually go into effect. It's equal opportunity for people with disabilities to provide reasonable accommodations. Number 2 is state and local governments. It outlines the administration process to be followed by that state and local government. And it applies to all state and local governments. The third one is public accommodation prohibits private places of public accommodation for discrimination against individuals with disabilities. It sets the minimal standards for accommodations, like if you're going to make like a new facility, you need to go, like it sets that what you need to do and put in the elevators or ramps if you have an extra floor. The third one is telecommunications. It's enforced by the FCC. It requires closed captions and federally funded public service announcements, and it's also requires relay services that allow individuals with hearing and speech disabilities to use the telephone. And then the last one is miscellaneous, which is just, it tells you what is considered a disability, what's not, how it relates with other laws and state immunities. And that's our presentation with HR laws.
Good, thank you.
Can we stop it?
I get it.
Yeah.
That's what I was thinking.